Dear friends, I'm Valfredo Wardi, and I'm back. We are once again offering you a magnificent seminar. Today, we'll have an international live. I chose myself this live. It's about the specter of the U.S. Department of Justice on the world. It's very wide jurisdiction. It's tentacular activities all over the planet. On the framework of the Lava Jato operation, we worked in close contact between the Brazilian federal prosecutors, the Brazilian Department of Justice, and the DOJ. Our guest today is the best person to address this topic. He's no longer with the DOJ, but the DOJ will never be the same after he has worked there. He dealt with corruption, fraud. He was, in a way, the number one in that organization that is a kind of global police. All those who have business with the US are under the jurisdiction of the DOJ. All those in contact with the US, number one power in the world, are under the gaze, under the specter of the DOJ. In order to discuss this topic with Robert Singh, who is now a private sector lawyer, has been for 1 or 2 months in the US, and the most specialized law firm in the US in terms of compliance, Quinn Emanuel, to discuss this with him. I have my dear friend Gabriela Scanlon, who is the first Brazilian woman lawyer who opened a law firm in the US. She's a great lawyer. She knows the US justice system. We also have Dr. Valdir Simão. He was the Controller General in Brazil, in our government. He's the Vice President of IRE. He's one of the persons that knows the most about the Brazilian state. And Enrique Machado, the chairman of IRE Mercado, the former director of the Brazilian SEC. And beside myself, this is a very special gathering of stars, Brazilian star as well as an American star, Robert, to deal with a topic that is of interest for all the corporate community in Brazil and elsewhere in the globe. We'll do this in Portuguese as well as in English. You can hear Robert in English. You just select the English channel. And those who would rather hear in Portuguese, you select the Portuguese channel. So this is a public utility seminar for Brazilian, Latin American companies, global companies. IRI is very happy to hold this event, and we could not start this seminar without giving the floor to my dear Gabriela. She is the translator between systems. She will show us the details of the American model. And as Robert will be speaking, she will help us through that. Gabriela, it's a pleasure and an honor to be here with you. Good morning, Valfredo. It's a pleasure and an honor for me. I thank Iris for its invitation. I thank you for this invitation. It's an honor to share this panel full of stars of the law world. It's a an opportunity, a unique opportunity for our listeners. They will hear from different professionals, from different uh, law systems, penal systems, criminal systems, about this similar trajectory. We have here an ex federal prosecutor from the DOJ, as you said, Robert Singh. Robert is known for leading a department with over 100 federal prosecutors, as well as for organizing one of the most successful campaigns of the DOJ, aiming at prosecuting and investigating and prosecuting manipulative market conducts, spoofing. In Brazil, it is quite discussed today. Robert was a faithful soldier who scrutinized FCPA, a very well-known acronym, as well as in Brazil, in the US, as well as in Brazil for a few decades. Rob Singh left the DOJ and joined one of the main litigation and compliance offices in the world, firms in the world. We also have Enrique Machado, who led SMA for years, and he's a prosecutor with the Brazilian Central Bank, our Fed, for a number of years. So we will discuss different systems, but we do have two persons with similar trajectories. So let's get started. Let's hear from our guest, my dear friend Robert Singh. You have the floor.
Well, it's an honor and privilege to be here. And so when I was asked to join the esteemed colleagues on the panel, I asked Gabby what we'd be talking about. And I heard that the title of the panel was The Specter of US Enforcement Globally. And the truth of the matter is the United States has very, very broad jurisdiction. Generally speaking, the states, the Department of Justice, the federal prosecution arm of the government, has the ability to prosecute conduct if it just touches through an email, through a bank transfer, through a telephone call, the United States of America. That's kind of one piece of it. Any company that's publicly traded in the United States of America is subject to our laws and criminal jurisdiction. And then ultimately, the department can also prosecute cases where the effects of the conduct resound in the United States. So if there are victims of fraud schemes that are principally executed offshore, and those victims are found in the United States, whether they're citizens or not, broadly speaking, the US has jurisdiction. So that has given rise, I believe, to a perception that the states has some type of global mandate. And that's not entirely true. There has to be, and there is always, some nexus between the offense conduct, whether it occurs in Argentina or Nigeria in the United States of America. So happy to talk all about the nuances of federal criminal law, how we did things, why we did things, what the interest in doing things was. But I'm all yours today and happy to give you anything that's not a state secret. I'm happy to talk about.
Muito bom, Rob. Essa é uma notícia
Great. This is good news. We will exploit you to the maximum to learn from you. Before we start our conversation, let's hear from Dr. Valdir Simão and from Enrique Machado. Good morning, Dr. Simão. Are you well? Yes, I'm very well, as usual. I'm very glad to talk to you, Gabriela, Enrique, Robert. It's an honor to be here. This chat is very important. I think that for Brazilian companies, it's crucial to understand what happens, especially in the US. There is a saying who goes like this: what we do here, we pay for in the US in terms of violations. And this is my first reflection for Robert to explore with us. This is it. Over the last years, there was an important evolution in the enforcement of the Brazilian anti-corruption law. Brazilian companies have collaborated with control agencies, the federal prosecutors, and these collaborations take place in the framework of the states, such as Minas Gerais, where we have an important agreement. And my reflection here, taking into account the interaction between Brazilian and American authorities, Robert, what's the concern? What's the point that Brazilian companies have to be attentive to when collaborating in Brazil? How can we assess or evaluate the repercussions of these collaborations in the US? They can have businesses in the US, clients, bank accounts, email servers. How much, to what extent, and how I, as a Brazilian entrepreneur who wish to collaborate with American authorities due to, in respect to a crime or a misdemeanor committed in Brazil, and how can I assess this, the repercussions?
Sure.
Great question. It will be a very important conversation. Let me ask Enrique to take the floor, and then Robert will discuss both questions. Dear Enrique, good morning. Are you in Brasilia? Good morning to all of you. Good morning, Gabriela, Minister. Good morning, Robert.
Thank you very much. Eu não estou em Brasília agora, eu estou em Salvador.
I'm not in Brasilia. I'm in Salvador, Bahia. I will go to São Paulo and then to Brasilia. I go back and forth. This debate among stars will be great. I will try to discuss the Brazilian SEC, talk about market manipulation. I know Robert was very important to characterize spoofing in Brazil. In 2018, I was in charge of this first case of spoofing in Brazil. Let's discuss Embraer and Petrobras, the well-known cases, and let's discuss the conditions to open a criminal prosecution. We would need a whole day to discuss this and improve on how it's done in Brazil and in the US. I'm not starting with a question. Let's hear from Robert what he has to say about what Dr. Simão said, and I'll try to chip in. Robert, would you please discuss what Dr. Simão said? And after that, we do have questions, important questions, to clarify our listeners' ideas. But Dr. Simão's question is a good start.
Sure. And I'll try to frame the issue in my own words to make sure we're on the same page. As I understand it, the question is Brazilian companies in business that operate in Brazil, what types of acts and what type of conduct will expose them potentially to liability, criminal or civil, in the United States? And so it's a great question. I'm sure it's a question that many of you are on this call to hear about and know specifically. So I'll describe it for you in as much detail as I can. First, and principally, if a company in Brazil elects to avail themselves of the U.S. public markets by listing on a stock exchange, or whether it be the New York Stock Exchange or the NASDAQ exchange, for example, that act will expose the company to a slew of legal obligations and a slew of legal risks. The idea being, if a company is listed on a public exchange in the United States of America, there is an implicit stamp of approval by US authorities. The company has proper controls, proper processes, proper management, and plays fairly and by the rules. And so any company that lists will need to maintain an adequate compliance program or be subjected to civil or criminal liability. And of course, the payment of bribes and kickbacks to retain business would be jurisdictionally appropriate as to that entity by virtue of the fact that they're listed on an exchange in the United States. So the first thing is, if you want to list on an exchange, you're going to be exposed to a panoply, a slew of federal laws, criminal and civil. So that's the first category. The second category is if a Brazilian company wants to do business in the States through an affiliate or a subsidiary that is incorporated in the States. That fact as well will expose both the subsidiary and the parent entity in Brazil to civil and criminal liability. So the way US law works is the acts of any entity that's incorporated in the States by its employees or agents can be imputed, criminal liability can be imputed to that entity, that domestic entity in the States, as well as the parent company in Brazil. So the second consideration I would be thinking about is the extent to which a Brazilian company may or may not want to incorporate the subsidiary or an affiliate in the United States. And then third and finally is the broadest kind of jurisdiction, which is anything that happens in the States the US government has authority over. So to the extent that a Brazilian business or companies or interests want to engage in transactions with US companies, want to engage in transactions on US soil, want to attend meetings attendant to transactions or deals on US soil, those acts as well will subject Brazilian companies and their employees and agents to liability here in the States.
Muito bom, muito bom. Eu gostaria
Great. I'd like to ask you a question, if you allow me, in order to guide our attendees. Robert, how this jurisdiction can be enforced? It's clear that the United States have to respect, and they do, the jurisdiction and sovereignty of other national states and jurisdictions. And how does it take place in practice? If the DOJ wishes, for instance, to prosecute and punish a company, it has to do it in the US. But how does it do it? By cooperating similar authorities in another national state. How does the DOJ put people involved in crimes under arrest? Those people have to be in the American soil, or are there agreements, or how does it work? Please introduce our listeners to this universe of possibilities for the American authority relative to other countries.
Sure. There are two things that are kind of embedded in your question. How do US law enforcement authorities put hands on individuals, criminal actors? And then how do US authorities enforce indictments and judgments against corporate entities? So with respect to the first part of your question, it's pretty easy. Obviously, if you're in the States, you can be arrested and likely will be arrested if you've been indicted. But you don't have to live in the States. So if you're traveling for a vacation or you stop over, even for an hour, there is something called a red notice that goes up both in the United States and with cooperating countries around the world. And that red notice calls for the immediate arrest of the traveler. And so in any nation where we have cooperative agreements, where there's an Interpol type relationship, you can expect that the red notice is up. The individual who has been indicted secretly in the States will be subject to arrest and almost certainly detention in the country where they are ultimately arrested, whether it be the United States or a member of the European Union. So that's one way in which US authorities put hands on, physically take possession of a criminal defendant. The other way is just through the extradition process. There are treaties by and between the United States of America and various nation states throughout the world. And these treaties call for, under certain circumstances, the extradition of individuals. The extradition is a fancy legal term for the giving by a foreign sovereign to the United States of an individual who's been indicted and criminally charged. So that is another mechanism that U.S. authorities can avail themselves of to actually obtain possession over the physical defendant. So those are the principal ways in which U.S. authorities take possession of criminal defendants individually. So with respect to companies, it's much easier. If a company does business in the United States of America, they're going to have, by virtue of their business, an agent, some agent, whether it's a clerk, whether it's an executive, whether it's a mailroom operator who is present in the United States. And as long as that exists, they can be served with legal process and indictment, and they can be charged. And ultimately, a judgment brought against the company, that is a criminal conviction, can be enforced in a number of different ways. Number one, the department can take property of the company, freeze its bank accounts, and take its money. It can do a variety of things to enforce a criminal judgment. And so the only way to mitigate that risk is to essentially have no assets in the United States. But even then, if U.S. authorities identify assets that are overseas in nation states that are friendly to the United States, they can seize those assets. And so the truth of the matter is, if a business is doing work in the United States, that's a Brazilian company, and it's engaged in criminal conduct, rest assured there are mechanisms and there are enforcement tools that can be used by the department to, number one, arrest its executives and employees, and number two, take its assets if ultimately there's a corporate indictment and a corporate conviction.
Muito claro, muito bem explicado
Very clear, very well explained, and I suppose it's surprising for a number of people. Before giving the floor to Enrique, because I know he wishes to ask questions, you might say a few words and ask Robert to explain a number of other important things for us. Of course, Alfredo, I think that we've talked about jurisdiction, the interest of the US in putting in this, disseminating its tentacles around the world, and you cannot deny we are Latinos. We are in Brazil, and we would like to know whether our neighbors and our countries, our region, is taking into account, if it is, for the near future. Robert, can you explain what do you think about the enforcement policies in cases that can be deployed, such as Lava Jato and other investigations? And which countries are more relevant in this list of targets or possible targets of the DOJ? That's based on our experience. And let me add something. We would like to know if we could go to Disneyland very soon.
So on the Disneyland point, there was a time about 2 months ago where I could tell you who should and shouldn't go. But those days are over. I think I still know who's on the list. But with respect to the question, I think probably a lot of people are asking, and it's a question that's probably not just one that's openly contemplated by Brazilians, but Europeans as well. And that is, how does the Department of Justice decide where to go, where to prosecute, and what is the analysis? Is there a rhyme or reason? And so, contrary to popular belief, I am here to tell you, because I ran the program, there is no targeting. There is no targeting. We don't have a list of countries. And we say we're going after Brazil, or we're going after France, or we're going after, pick your nation state. That's not the way it works. Like any good prosecution office, we follow the evidence. But that is a platitude. So I'll be very specific about what I mean by that. And there are objective indicators of fraud and corruption that exist in systems of record in the United States. For example, if you're a foreign official and name your country, and you've opened a bank account in the United States, and there is significant inflows of cash deposits into your bank account, that is going to generate something called a suspicious activity report, which banks have to, by virtue of American law, report to the US authorities. And so there are a number of leads of this variety that pop on the DOJ's radar. And those leads oftentimes end up being a treasure trove of information. For example, in my hypothetical where a foreign official from a foreign nation has parked money or bought property in the United States in ways that are suspicious, the bank application itself will have the email address associated with the individual. Authorities can get a search warrant for the email address. They can look through the emails. The emails might establish probable cause for a crime, coupled with the suspicious transactions in and out of the bank account. And then when that official comes to the United States, he or she may be arrested. They then might decide to cooperate and give the US authorities information on a whole number of different bribery schemes. So one good investigative lead coupled with one cooperating witness opens up a slew of opportunities, a host of opportunities for US authorities. And so what you've seen is efforts undertaken against certain companies and individuals that have themselves spawned further investigations because folks associated with those entities are cooperating with US authorities. And so if we get one or two cooperating witnesses that have information on Brazilian authorities, you can bet more than likely they have more information about other criminal schemes in Brazil. And so crime begets crime. And so once we have a cooperating witness in a certain region or with respect to a certain company, that individual will likely be mined for months and years about all the information he or she has. But to come back to my core point here, there's no targeting of countries. That said, I will tell you that there are certain citizens throughout the world who find it financially advantageous to do business in the States. The US financial markets are, I am largely proud to report, safe and secure. The real estate markets, for the most part, are safe and secure. So it makes sense why folks would want to do business or put their assets in various accounts or real estate investments in the United States. So I think as a general proposition, there are a lot of officials and businessmen from South America that do enjoy parking their money in the United States of America. And when that happens, that provides US authorities with an opportunity to arrest and interrogate those who would come to the States who might be engaged in criminal behavior. Now, conversely, a Chinese national who's engaging in foreign bribery might not decide to park their money in the United States or buy assets in the United States. They might put it in Switzerland or in an Eastern European bank or in the Bank of China. And so it's just a function, really, at the end of the day, of where the criminal actors travel, where they do business, and where they conduct their affairs.
Muito obrigado, Robert. Obrigado, Gabriela.
Thank you, Robert. Thank you, Gabriela. I'm sure that Enrique would like to comment and ask questions on the interaction between DOJ activities and market coordination. The DOJ activity coordinated with the SEC in the US and elsewhere to protect investors. When we discuss spoofing, well, there are a number of modalities of fraud that suppose the internet, the network, the environment, and new technologies. Enrique, I'm sure you would like to tackle this. Yes, I'd like to address this topic, but not forgetting, well, let me ask about spoofing as well. Let me deepen this debate. It's very important. Last year, the criminal division of the DOJ, together with the enforcement division of the SEC, they updated the guide for the FCPA. And now it's clear, the criteria are clear to start or to decline a criminal investigation in the US. And so this transparency about rules for starting or not a prosecution, as we have here in our law as well. I'd like to hear from Robert, what are those criteria? How beneficial is the clarity among about criteria that would lead to a prosecution? And can you give us examples of when these criteria would lead or not to a prosecution in the US?
Sure. Happy to respond. It's a very, very important issue, and one that I think we sound pretty proud of. And let me, before I explain the mechanics of how it works, I want to give you an overview of the general principle. And the general principle is the department wants its enforcement regime to be predictable, so that business can make informed and educated decisions about certain courses of conduct to take. That is to say, we don't want the system to be arbitrary or to be hiding the ball, because that disincentivizes businesses to do business in the United States. So we want to be very clear and transparent regarding the circumstances under which we would entertain a criminal case or a criminal prosecution. And so I'll talk principally right now about corporate cases, crimes that would be charged against entities themselves, not necessarily people, but entities. And one other overriding premise is that our program is predicated upon the belief that corporate actors, unlike many people, are fundamentally rational. They have boards of directors, they have executive management who are, by and large, honest, law-abiding, and make rational decisions. After all, they're business people, and that is their business, to make money and rational decisions. And so our enforcement regime provides an incentive structure and a consequence structure. And here's what it is. If the department learns, or if a company, learns of evidence of a crime on its own, remediates the problem, immediately self-reports it to the Department of Justice, and fully cooperates, they will not be charged. Period. Full stop. It is essentially an amnesty program with one exception. To the extent the company received ill-gotten gains, it's got to pay those back. So it can't report a crime and then say we're going to keep the fruits of our crime. It's got to either pay the money back to the Department of Justice or the victims associated with the crime. But that's a very, very clear programmatic initiative to incent companies to do the right thing. Now, if companies don't do all three of those things, that's self-report, fully remediate, and fully cooperate, they are presumptively going to get charged. And the degrees of charging kind of vary in the US criminal system. They're at the high end, at the severe end, there's something called an indictment, which is a criminal charge, and a plea agreement, which is an admission of liability in federal court. That is the worst thing that can happen to a company, because when there's a criminal conviction, there are consequences associated with it. Two that come to mind. Number one, if it's a publicly traded company, almost certainly the company will be delisted and will likely, their access to capital and debt loans will dry up and they'll die. So an indictment 9 times out of 10 will kill most publicly traded companies. And number two, there are debarment consequences. The mere fact of an indictment or conviction in the States for many companies will prevent them from doing business in certain sectors, whether it's accounting, government contracting, or the commodities markets. They will be barred from operating, which also, practically speaking, means the company dies. And so the last thing a company wants to do is be indicted and convicted, because essentially they cease to exist, which is what happened with Arthur Andersen, a very large US accounting firm over 15 years ago. So that's the most severe consequence. Then there are graduated consequences down. There's something called the Deferred Prosecution Agreement that is given to a company that doesn't merit an indictment, but engaged in pretty bad behavior. And in that agreement, the company has to admit to wrongdoing and does get charged, but that charge is deferred, hence the word Deferred Prosecution Agreement, for a period of 3 years for the company to demonstrate its good conduct. And at the conclusion of that 3 years, charges are dismissed and there's no criminal record for the company. Then the third option is something called a Non-Prosecution Agreement, which is again an admission of liability by the company, but it's simply a private contract between the Department of Justice and the offending company. There's no court filing, there's no charge, and there's certainly no conviction. And so there is a range of corporate options available, starting with an indictment and plea agreement, deferred prosecution agreement, non-prosecution agreement, and then of course a full declination, which again is available for companies who fully remediate, fully cooperate, and self-report. And so the idea behind this program is companies now know all these different vehicles, kind of know the circumstances under which they would fit into each one, and can make informed and rational decisions about what they want to do. But the one caveat I'll say, and I need to probably be more careful now as a defense attorney, but I will say, as a prosecutor, if we ever found out that a company considered self-reporting and made the decision just to roll the dice, and we found out about the case independently, it was not a fact that was well received by the department. So, if the company is engaged in discussions about self-reporting, ultimately, if it chooses not to, and facts related to that decision-making process come out, it's not necessarily a dispositive fact for the department, but it's not a good thing. That evidence is a belief that the company could get away. They made a calculated decision to try to get away. So that's the program. That's kind of how it works. It's been, I think, well received by business. They're pretty clear guideposts about what the rules are, but we'll see how it's actually applied in practice in the next 5 or 10 years.
Muito obrigado. Ministro Valdir.
Thank you very much. Dr. Simão, Valdir Simão, you played an important role in enacting the Brazilian anti-corruption law. And this law, in a way, and you are a voice, a protagonist in calling for a discipline in agreements. You certainly have something to say about the situation of companies relative to the American Program for Controlling Corruption and Fraud. I'd like you to interact with our guest about this. It's very important. We are still learning this process of negotiation, as you explained, Dr. Singh. It's quite wide, this. We are talking about conducts that have to do with market protection, financial systems, and in Brazil, we have a wide set of agencies that can enforce sanctions and negotiate leniency agreements, as well as the prosecutors, the office, which goes beyond all this. But one thing we are still discussing, and the American experience is crucial here. In fact, there are 2 points I'd like to explore with you. These are the following. The first one, you've already tackled, which is the possibility of self-report by the company and giving back the profits, the disgorgement. But how do you calculate this profit? And this might be the huge disputes between companies and authorities in Brazil when negotiating leniency agreements. So how do you calculate how much the company has to give back? And the second aspect is related to a certain extent to what you said, the decision process, when they decide to collaborate or not. The company will assess whether it's worthwhile for it to collaborate or not, considering the risk to be found out, the sanction, that the penalty that would be applied to the consequences for its reputation, etc. In Brazil, we are discussing that. The responsibility or liability of directors of the company, the board of directors, is clear. They are responsible, but what's the level of responsibility of the compliance officers? He is aware of the violation, and the company, the board of directors, decided not to report to the authorities. And how does it go in the US? The compliance officer, as a person, as an individual, is he liable as well in a situation like this? He's held responsible?
Sure. I'll tackle the questions most recent to the former. So first, with respect to a compliance officer, the analysis is actually pretty simple. If the compliance officer all participated or turned a blind eye to the offense conduct during the time of the conduct, the individual might not be, but can be criminally charged in connection with the scheme as a knowing participant. If, however, the compliance officer learned of the misconduct after the fact, and assuming there's not any pre-existing obligation between the company and the department, the company and the SEC, the company and the SEC, or any other government regulator, businesses are free to make decisions to report or not report. And the compliance officer will not be, as the company would not be criminally liable for its failure to report. There might be consequences, prudential consequences associated with that. That is, the department might not like it very much. The SEC might not like it very much, but there would be no criminal liability flowing from that decision not to report. Again, if the compliance officer knew about the conduct at the time and let it go, the analysis is completely different. With respect to boards of directors, again, same analysis. If the board knew of the conduct at the time, participated, turned a blind eye, it could be held liable. That generally, in our experience, is not the case. Many of these schemes are hatched at mid-level management levels or below, frankly. And so it's very, very rare for the board to have been complicit in a criminal scheme. In those instances where it occurs, it calls for the most severe sanction possible, in my view. Because at the end of the day, the board of directors is the company. It's provides the strategic direction for the company. And I will also say, if we ever learn, and when we have at least on 2 occasions when I was there, a compliance officer being complicit, in my view, that calls for the severest sanction possible, because the compliance officer is the cop, is the company cop. And if the company cop can't be trusted to police its own organization, then in my view, the company is fundamentally flawed. And so, again, unless they're involved in the underlying conduct, no liability. But if they are, the severest sanction possible, imaginable, at least in my view. And I know my colleagues at the department agree with that. So moving now to your first question, how do we calculate profits? I am sad to report that I know the law on this probably better than most. It is, I'll give you the formula, then I'll explain where the nuance comes in. US law is very clear on calculating profits. It is revenue minus direct costs equals profits. That is what the case law has firmly established is the formula. The problem is, what do you put in direct costs? There are accounting principles that are used, but anytime you're negotiating with a company, they want to park as much in direct costs as possible to keep as much of their profit as possible. So there is inevitably and invariably fights by and between the department and corporate counsel about what direct costs are. So you have this giant investigation that lasts for 3 years. We've established liability. Everything's tied up except for one thing. We're fighting for months over what a direct cost is and isn't. And at the end of the day, as I noted before, the department has the ultimate leverage point. It can just indict the company. And so we always strive to be reasonable to a point. If you want to negotiate about direct costs for 3 months, you can do it, but on month 4, you might get indicted. So, reasonable to a limit, but at some point in time, the discussion about what or what is not profits will likely be decided by the DOJ.
Muito bom, muito esclarecedor.
Great,
Gabriela, antes de voltar
very
para-
clarifying.
talvez
Before
mais
we
uma
give
vez,
the
eu
floor
queira,
back to Enrique,
fazer alguma
you
pergunta
might wish to ask an additional question so that our listeners organize their ideas. Yes. As we are discussing a topic that is included in the discussions of all Brazilian companies, compliance, and if we look back 10 years ago, compliance was not a topic, important topic. We didn't have specialized lawyers, we didn't have practices and offices in the US. This has been the case for a long time. And why is this important? Last year, the DOJ besides publishing the new version of the FCPA, also published the directive about compliance problems. We know it's cutting. The company might have a great compliance program on paper, but if we call the company and it doesn't, the telephone doesn't work and you cannot put your complaint. Well, I'd like to ask Robert what this new directive brings and what is important for companies in terms of training their compliance soldiers. What do you think about this?
Sure. For those of you that don't believe in compliance programs, I'm here to bring you some religion. They're an important and almost outcome determinative piece of a corporate structure, and I'll explain exactly why. So I have just gone through with you the different options available for the department to charge a company: indictment, DPA, MPA, declination. Probably the single most important factor by department prosecutors in deciding which of those outcomes to impose upon an offending company is the existence of the company's compliance program. The idea is companies that are trying to do the right thing, that are in good faith trying to prevent crime itself, and when it occurs, because sometimes it will occur and everybody recognizes that, does the right thing by detecting it, remediating and disciplining its employees. Those companies deserve appreciable benefits in many different ways, in the form of resolution, whether it's an indictment down to a declination, and the amount of money, the amount of penalties they're forced to pay, and whether an independent compliance monitor must be imposed to self-police the organization. And so the first thing I would say about compliance programs is any business-minded executive wants one because it reduces exposure. The whole principle behind a compliance program is to prevent crime. Preventing crime by your organization reduces your risk profile. So just from a dollars and cents perspective, you should want a compliance program that's effective. But separate and aside from that, if you have one and bad stuff happens, and it will, the fact of your compliance program and its effectiveness is probably the most important consideration that is taken into account by the department when it decides how you should be punished and the extent to which you should be punished in terms of dollars and cents and remedial measures. So there are a whole bunch of different reasons to have a good compliance program. And I completely appreciate that from any executive standpoint, it's a cost center. You're paying money. But I would think of it slightly differently. I would think of it as nothing more than a very, very important life insurance policy. It is something that is designed to prevent you from getting sick, your organization from getting sick. In the event it does get sick, it provides coverage for the costs associated with the company's conduct. So it's a critical thing, and not having one exposes corporate entities, at least that do business in the States, to great and grave risk, at least in my view. Gabby, does that answer your question? I think there's probably more to it, but I'm happy to follow up.
No, that's perfect. Thanks, Rob.
Muito bom, muito bom, muito bom mesmo.
Great,
Professor,
very, very good. Professor Henrique Machado,
me mandou uma mensagem aqui, você está
you sent me a message. You say you are desperate to ask your question. Please be my guest. I still wish to ask a question concerning international corruption before tackling the market situation. In 2016, the SEC, the Brazilian Federal Prosecution Officer, and the DOJ had an agreement to close an agreement concerning the selling of airplanes to different countries. This kind of agreement avoids duplicating international avoiding bis in idem and criminal and administrative persecution. I think I've seen that DOJ is intensifying its anti-piling-on policy. Can you tell us how the DOJ is conducting this policy and what benefits are expected from it?
Yes, that is the question of the day, especially when it comes to international corporate crime. Let me set the stage here. There is a policy at the Department of Justice that implores prosecutors not to impose excessive fines when other remedies are available by U.S. civil authorities, U.S. state authorities, and of course, foreign authorities. And it is very general and very broad. Pardon me, I'll turn on my light here. It is very general and very broad, and it doesn't provide much guidance or detail about how the policy is supposed to be applied. So what has happened is a practice has evolved over the last 3 or 4 years. And the practice is one that you might expect, and I think that one you will have faith in, which is simply when there are different sovereigns involved in a case, take a Brazilian investigation, where the Brazilian authorities seek to achieve a resolution. The department will take into account the various national interests at stake. Where did the conduct occur? Who did most of the investigation? Where are the victims located? Where is the company located? Where are the profits realized? And there will be a balancing analysis, and there'll be a discourse between the department and the foreign sovereign about who gets what and who takes primacy. And that is in function and in practice how it works. There are no set of rigid rules, but the principles I outlined for you is what happens really on a weekly basis. It's really in the department's best interest to abide by those rules, because the worst thing that can happen for international cooperation is the Department of Justice says, we don't care what you think, we're going to do what we want to do. What happens then is foreign sovereigns and enforcement authorities stop cooperating. It inhibits the department's ability to get evidence. And the same is true for foreign sovereigns. The worst thing they can do is say, we don't care what you think, department, because the foreign sovereign, wouldn't have access to certain amounts of evidence and testimony and witnesses. And so the anti-Palion policy at its core is meant to force department prosecutors to think proactively about cooperation with state authorities here in the States and, of course, foreign authorities. And I'm proud to report that since its promulgation about 3 years ago, there has been very, very little heartache or heartburn about its application. But I do concede that for those on the private side, there is little guidance about how it is applied in practice. So I hope kind of my statements can provide some or give folks some analysis to take home. And that is simply, once again, a number of different factors are considered, but at the end of the day, who has the most equity? Where did the conduct occur? Which company got the money? Where are the victims? Those are the principles that will guide who takes primacy over the case.
Muito bom, muito bom.
Thank you. Dr. Saldir Simão, would you like to close this introduction? No, I'd like to add that this collaboration between DOJ and the Brazilian authorities is taking place in negotiating agreements at the high levels in Brazil, federal prosecutor's office, etc. It's not the same instrument, but we have coordinated actions among us. The agencies take into account the payment capacity of the companies, and so the penalties are proportionally distributed, considering the relevance of the case, the presence, whether the conduct took place in Brazil or not, and this has worked fine. And for companies, it's very important as well. My first question concerning how companies see the collaboration with Brazilian authorities goes along these lines. It's important for companies to know that the negotiation of a leniency agreement in Brazil, if the company is submitted to American jurisdiction, this company will have to discuss the case with DOJ, etc., because information will be sent to these agencies or authorities. I'd like Robert to give his personal opinion. You all know I'm concerned about companies. American companies have a level of complexity and a way of financing themselves that is very different from Brazilian companies. Great large American companies get their finances from capital markets. There are no controllers. They have thousands of shareholders, and they are more sound. And it's easier to uh, transform their company culture or corporate culture, whether when there is a corruption culture or there are corruption practices. It's easier to clean up these companies when there are no controllers. It's very easy. You remove the board of directors. In Brazilian companies are controlled by a number of people. Even large companies have private financing through banking financing or their own financing, or meaning by from their own growth in a recent past from government subsidies, and more recently from capital markets, but not at to the same extent as in a developed capitalistic country as the US. Here is my reflection. We have the American jurisdiction, the jurisdiction of all these state agents, the SEC, our Fed, all the agencies that make up the control apparatus in Brazil. And we also have the state level control agencies in Brazil. Each Brazilian state, we are a federation, has its own control agency, besides the state level prosecutor's office. And here's my question. How heavy this large control apparatus how heavy can it be if we make it too complicated or too wide, make this control apparatus too wide, too large, we might end up preventing the existence of a corporate environment that is necessary to generate jobs in Brazil and elsewhere.
Yep. Look, I think it's beyond a fair point. I know there's a view in the United States of America that overregulation, that is the promulgation of too many laws, rules, and requirements, stifles corporate growth. And you know, at a certain level, I completely agree with that. But here's what I would say for international business. There are a number of different legal risks, of course, but the principal one, and let's just be real about this, the principal one is the FCPA. Okay, so although there might be, the United States might be perceived to be a regulatory state with all these rules and requirements and complexities, for international business, there's really two bodies of law, at least in that three bodies of law that I would be worried about, and only three. I shouldn't say only three, but principally three. FCPA, you can't bribe folks to get business. Can't do it, at least in the States, if there's a US connection. Export controls, there are certain products in certain countries that are embargoed, and if you have a business that operates in the United States and those products go to an embargo country, there's going to be criminal consequences. And then antitrust. You can't collude to fix prices. And again, the jurisdiction on an antitrust case is very, very broad. And I guess I would add in a fourth, which is if you're a publicly traded company, a Brazilian company, that means you're listed on an exchange. You know, any false statement in your securities filings will be securities fraud. So, you know, everything is about assessing risk. And yes, there are lots of rules, and yes, there are lots of regulations, but good lawyers find a way to boil it down to its essence for their clients. And if you ask me, it would be those four areas that I, as a lawyer advising a foreign company, would focus on. So, you know, to the extent that folks are out there thinking about a compliance program, the compliance program, at least in my view, would look principally at those four areas. And there might be other unique U.S. laws at issue depending on your sector, but really at the end of the day, Wilfredo, I think it's those four. And so I wouldn't be terribly concerned about criminal actions outside of those four spheres. I haven't seen a lot of them. And I think it's simply a risk assessment. But I hear your point loud and clear that there comes a point in time when too many structures, too much regulation, too many rules stifles business and inhibits business from wanting to come to the United States. The flip side of that is, I think that those who do business in the States have a view that there is going to be fairness, because if you don't play by the rules, there's this apparatus that will come after you. And so, for those that do want to avail themselves of the U.S. markets, I think there is a relative comfort in knowing that there are watchdogs that are hungry and will bring actions if necessary against, offending companies.
Entendido. Muito bom. Muito
Yes,
bom.
well understood. Very good. Gabriela, I think we should hear from Henrique Machado. He can now tackle the market issues that are very, very important for our attendees. Henrique. Thank you, Valfrido. Our time is almost up, but I had to mention spoofing and market manipulation. Spoofing is a kind of market manipulation based on insertion of purchasing order or selling orders of an asset that it will not be executed. They are just put to create fake movement, thus manipulating prices. In 2018, I conducted the first trial, the first conviction for spoofing in Brazil. It already existed in the US, and I drank for that source, very good source, although I had to adapt it to our context, to our legal framework. But since then, well, we were discussing whether spoofing is an infraction, if we could create an infraction. But the question in Brazil, Robert, when we compared with the US, the question was, to what extent you need, what kind of evidence you require, you need to reach a conviction for spoofing, market requirements, depth, number of insertions, and other material evidence, such as testimonials, witnesses. My question is, what kind of evidence you concluded that are enough or sufficient to convict on market manipulation of the spoofing kind?
Enrique, I am not the one to answer because between the two of us, I have tried a spoofing case. You have tried a spoofing case. I lost mine. You won yours. So really the question is for you. But since you asked me, I'll give you my view. We have taken the position since my first loss. Our view is that the evidence required is data plus. And what I mean by that is the trading data needs to be substantial. And so what we would do is we would go into the entire market. We get all of the data and we identify the 5 or 6 worst actors based on a formula that had been given to us by cooperating witnesses. That is to say, a cooperating witness would say, if you see A, B, and C, and D in the market within 2 seconds, it's manipulation. And so we reverse engineer an algorithm to identify that conduct. And then we would create a list of the worst offenders. And so armed with that list, we knew who the bad guys were, but data is not enough, clearly. And so what we were able to do is utilize covert search warrants to get email communications and critically, internal chat communications. So the traders would oftentimes chat, use a chat function, not unlike the chat function on Skype, in real time while they were trading to talk about their activity. And so armed with either a cooperating witness in data or data and these chats, oftentimes referring to the practice itself as manipulation or spoofing, we were confident that at least we could get it to a jury, the case to a jury, and have a chance of conviction. Now, the best case, and we've had a couple of them in the last year, are cases involving data, a cooperating witness, and chats, contemporaneous communications regarding the criminality of their conduct. In those cases, we've been successful. We've won every one. We have a very, very significant one involving 5 traders at JP Morgan coming up, scheduled for trial this fall, but is likely to get continued to the springtime. But to answer your question bluntly, it's going to be more than data, and it's going to be either a cooperating witness or contemporaneous communications, preferably both. But that's kind of our functioning modus operandi.
Valfrido, se me permite,
Valfrido, if you allow me,
o DOJ e a SEC também desenvolveram
DOJ and SEC also developed an unique algorithm. That's what I've heard. How could you tell us how this new algorithm was designed and how it is used in criminal prosecution?
Sure. It's without getting into the specifics, because I would literally be giving away state secrets there. It's just very, very simple. When witnesses would end up pleading guilty and cooperating secretly with us, we would ask them if they could explain for us how they were able to manipulate the market. And what we heard over time was that there are 1 or 2 common techniques. There's thousands of different techniques, but there were at the time very commonly employed techniques that involved, 4 or 5 simple steps. And so what we were able to do is kind of lock in through testimony, through witness statements, that formula. And we hired an outside forensic accountant to build an algorithm, just a computer program, to go into the data and identify those patterns. And every time one pattern was identified, that would be 1 hit. And then at the end of the day, we would look to see which traders and which companies had the most hits. And frankly, if these companies had compliance programs, they would have done what we did 10 years ago. They would have identified the conduct and remediated the conduct. It's not rocket science. So what we were doing is really what any compliance function does in modern society today, I think. But it is really rudimentary. It is really simple. But it is based at the end of the day on complicit cooperating witnesses explaining how they themselves did it, so we could replicate it in the market.
Obrigado.
Muito, muito bom. Muito
Thank
bacana.
you. Great. Gabi,
Tem que terminar, né? Infelizmente,
I think we should close.
com vontade de ouvir mais do Robert.
This way, people would wish to hear more about this, more from us. And so very soon we can hold a new event. Have you enjoyed this, Gabriela? And we will hear from you, from Simão Machado, and from Singh. Well, we leave here wishing to hear more about this. A few topics touched the tip of the iceberg. We still have a lot to discuss, and we could develop legal thesis on all this. We have to discuss the legal mechanisms are more developed in the US than in Brazil, and to self-report in the US is more interesting in the US than in Brazil. This is a teaser for a next event. I'd like to thank you. It's an honor to be here, and I'd like to be here very often to discuss this topic. Luiz Valdir, it was absolutely great. We could show a general picture of our systems, intersections, risks. I'm very concerned about the algorithms. I'm doing nothing wrong, but I will no longer buy shares. Our different authorities are learning. Our state is more and more able to perform surveillance and intelligence surveillance. And I hope this way we can improve our business environment, which is our main goal. Corruption or other market violation, I hope they are not decisive. They will not distort competition. And I hope we can improve the relationships between companies and states and among companies, competing companies. This is what we should aim for. And I'd like once more to thank you for being here and thank Robert, thank you, Enrique, and Gabriela. It was a great pleasure to discuss with you. Thank you. Dr. Machado, your final words. I would like to thank you for this opportunity, the opportunity to discuss with Robert. As Gabriela said, this was just a teaser, a taste. We tried to focus on the most interesting topics, those who are the word of the day, such as the anti-piling on policy. This is very important in our jurisdiction as well. What should we do for agencies not to overlap and generate increasing costs for cooperation? This is important here as well. It was a pleasure to be here, to hear from those who know from the inside and authoritatively all this topic. Thank you, topics. Thank you very much and be safe. Take care. The pandemic's not over. Thank you, Enrique. My friend Robert Singh, you were a showman here. You explained us all this. You answered our questions. You explained to our international audience the main characteristics of this interaction based on DOJ activity, this international interaction, the global interaction, and its importance it has to enhance our healthy corporate or business environment, more competitive environment. So let me give you the floor for your final words, but it was a great honor to welcome you here in Erie. Let's wish this is only the first one of many initiatives from Erie and yours. Thank you very much.
So I will keep this short, but I want to give a heartfelt thanks to you, Wilfredo and Gabby, for the invitation. This is my first speaking engagement since I've left the department. It's a place I loved very, very dearly for 10 years, but I'm happy to be providing counsel to folks on the other side. And here's the one thing I'll say, and maybe I'm just too close to the department still, but I can promise you the department acts in good faith, tries to be transparent. And it does have a broad reach, make no mistake about it. And there are risks. There are risks for Brazilian companies and frankly, all across the greater Latin American region. But those risks can be mitigated by just the simple things we talked about today. Compliance programs, and doing things to ensure that to the extent that there are problems, the conduct doesn't occur in the United States. So again, I want to thank you all. It's been an absolute pleasure. I'm glad my first time was with you all. So I hope this is the first of many.
Nós esperamos também. Muito obrigado, meu querido
We
amigo.
do hope it to. Thank you very much, my friend. Gabi, I congratulate you for the panel you brought together. You were the engine, the mentor of our incredible panel. I applaud you. Thank you, Valdir Simon, for your brightness. Dear Enrique, you discussed market issues that are very important. Rob and Gabi, keep well in the US, and we are looking forward to meeting in person.
Goodbye. Pleasure.